Welcome to Financial Insider Weekly. I am your host, Michael Gray, CPA. My guest today is Mark Erickson, and Mark is an attorney, family law attorney. His firm is located in Campbell, California. For you folks that are trying to pinpoint us from around the country or whatever, Campbell is located in San Jose, which is adjacent to San Francisco. We like to say San Francisco is close to San Jose. Anyway, Mark graduated with a JD degree. That's like the law degree from Santa Clara University School of Law in 1979. He was admitted to the California State Bar and U.S. District Court, Northern District of California in 1979. After working for another attorney, mostly in the area of civil and business litigation from 1979 to 1984, he started his own law firm in 1985. And he became a certified family law specialist by the Board of Legal Specialization of the State Bar of California, 1987. He has lectured and presented seminars for many groups, including as a teaching assistant and guest lecturer at the Santa Clara University School of Law. The non-professional stuff, Mark plays ice hockey, so he's a pretty tough guy. And I was just talking to him before the show. He has two sons, 22 and 25, and his oldest son is taking the bar exam, I guess, today, and today is July 26, 2011. So anyway, Mark, thanks a lot for being my guest today.
Yes. Well, thanks for having me here.
Okay, so you're saying, well, why would you have a divorce lawyer? It's because we're going to be talking about some divorce topics today. And I call this Divorce California Style. And we're just going to be talking about some of the basics related to divorce today. But as we get started, again, this is related to California law. Mark is a California attorney. I am a California CPA. And the laws do vary from state to state, so be aware of that. Also, we're talking really about, again, a complex area of law, and you need to talk to somebody about your own situation. This is an introduction to a continuing conversation that you should be having with your own attorney. But meanwhile, we're hoping that we can give you some good basic information, and maybe for some of you that may be on the fence, maybe after our conversation today you'll say, marriage doesn't sound so bad. So, and I guess I'm going to throw in my little 2-cent dig today or whatever, and that's that my wife and I are celebrating our 40th anniversary coming up here pretty shortly.
Congratulations.
And I won't say it's easy, but I will say it's been rewarding, and I'm glad that we're still together. Okay, so with that, Mark, let's get started with some of our questions here. Okay. So how do people get started with this process of getting a divorce? How does this whole thing sort of get initiated?
Okay, well, the paperwork is fairly easy. It's initiated by filing what's called a petition for dissolution of marriage. It's a front and backside document put out by the Judicial Council. And it doesn't have a lot of information other than the names of the parties, date of marriage, date of separation, names and ages of children, and then some boxes you check on relief you might be seeking. It's something that, with the help of an attorney, you probably could fill out in a few minutes. And the only real decision that usually takes much discussion is what is the date of separation, which sometimes is complicated and not terribly clear. And whether somebody wants to request spousal support or not. Sometimes that's something that's debated before people decide whether they want to check the box or not. And they almost always check the box that says they don't want to pay spousal support to their spouse.
I understand Arnold said that on his, but anyway.
Yeah, when they tell us on the news about celebrity divorces, they almost always tell us that the party who filed is seeking a dissolution of marriage based on irreconcilable differences, which is almost always the box that's checked. The other choices are incurable insanity, which is rarely checked. I've certainly never seen it checked. So it's almost always a dissolution of marriage based on irreconcilable differences.
Now, in California, do you need to prove that somebody's at fault in order to go ahead with a divorce action?
No, in fact, we talk about no fault, and by no fault what we mean is you don't have to have any showing other than one spouse needs to be able to say that they have irreconcilable differences that have led to the irremediable breakdown of their marriage. That's what we mean by no fault. So either party willing to say that, that's enough to terminate marital status, although it doesn't happen instantly. It takes a bit more than just filing the petition.
Yeah. Anyway, so it sounds like the getting started isn't so hard. It's what happens afterwards. Now, and also there may have been some pain that's involved in making the decision to go ahead in the first place. Do you have people that come to you sort of like for a pre-divorce count? Does this make sense for me to even think about doing this? Or?
Absolutely. And I'm sure most people, it's not an easy decision. I've had some people come back year after year over a long period of time and check in and say, things aren't going well, I'm still thinking about it. So I think most people put a lot of thought into it unless there's some traumatic event that occurs that causes them to make an instant decision. As attorneys, we have an ethical duty to not promote divorce, and certainly if people are interested in preserving their marriage, that's something attorneys normally would promote and suggest marriage counseling or really talk through it and make sure it's something they really want to do, because it's not something you want to start lightly with the idea that you might quickly dismiss it or using it as an attention getter, which I think some people do. They're calling out for attention from the other spouse, and that's a pretty difficult step to take, to file a petition just to get attention, but I think that happens. But I think most people that file, by the time they file, they've thought it through and they intend to do it.
Okay. So when is the right time to file for a divorce?
Well, timing can be significant. It isn't always. I always tell people the right time is probably when you've really made your decision that your marriage truly is over, that you've exhausted other possibilities, marriage counseling, and really thought it through, that this is something that you really do have irreconcilable differences. The timing may make a difference. For example, having a 10-year marriage, it can be a very significant amount of time on the issue of spousal support. And so someone might say, gee, my marriage isn't doing very well. I've been married for 9 years. Maybe I got to stick around another year or two before I file, because that might enhance my spousal support amount or duration later on. There also may be issues about debts that are being incurred, bonuses that might be received from employment where the date of separation makes a significant difference. But mostly I think the decision is my marriage really over, and is this the time to do it? Some people will wait, trying to be kind to the other spouse, avoiding, for example, filing right before Christmas or right before somebody's family is visiting from out of town or on a birthday, things like that.
Wow. Do you get, like, particularly when you're having these earlier meetings, is there a difference in the conversation that you have with men usually than with women as far as their orientation for this sort of thing?
I think the discussion is the same. I do see there are some gender differences. Maybe they've changed over the years. I've been doing this for 31 years.
Yes.
And of course, 31 years ago, we didn't see as many professional women. We didn't see women as the high earner, and I'm seeing now with a lot of younger people and shorter marriages, the wife is often the higher earner. And we see now, almost all cases, the father's asking for joint equal custody, which is something that we didn't see much 30 years ago. In terms of the decision-making process, what I've seen in my practice over the years is men that come in are more likely to be thinking about it and less likely to be eager to file, whereas women tend, by the time they come in to see the attorney, to have made up their mind and maybe are more likely to be ready to file a petition. You know, there's certainly exceptions to that, but that's what I see generally.
Do you see a lot of difference for people in different groups, like blue collar versus business owners versus professionals?
Well, in terms of the decision-making process, maybe
Yeah.
not so much, but the issues certainly can be different. And it may depend on the economy at any given time. Certainly
Yeah.
right now,
Yeah.
our economy has not been doing very well the last few years.
Mm-hmm.
And I'm seeing issues that I didn't see much, say, the prior 28 years.
Mm-hmm.
For example, it was very rare to see somebody that had a house where they owed more money than the house is worth.
Right.
Today, especially with younger couples, I'm seeing that it's very common that they owe more on their mortgage than their house is worth, which creates issues we're still struggling with. What do you do with a net asset or a net negative asset, or when the entire estate is a net negative estate? I didn't see that very often before, and now, at least with younger folks, I'm seeing that fairly commonly. People coming in that the only asset they really have may be a small bank account, a couple of cars, and a 401k account. Often they'll have a 401k, but the debts on the mortgage and education loans exceed the value of all the assets.
Okay. So what do you think is the most difficult area for you working through and getting into this process?
Well, from the attorney standpoint, I think sometimes it's having the cooperation of your client. They're often going through a lot of emotional difficulties, and of course they have their busy life, taking care of their children or working, whatever they're doing, and getting them to help us get necessary paperwork done is often difficult. We have a process in California where we have mandatory disclosure rules where both spouses have a continuing duty while the dissolution process is ongoing to make a full and immediate disclosure of all material facts and information concerning the value and existence of assets and debts, as well as income, and then any changes as they occur.
And they haven't even been doing that when they had a regular marriage going.
Well, that's right, and sometimes one spouse has all the information and the other one doesn't really know. But it can be a lot of work, and you're right, it's something they didn't do during the marriage. Some people don't keep good records, and sometimes neither party often really knows. It's surprising. You'll ask folks sometimes, well, what do you think your house is worth? And a lot of people surprisingly have no idea. How much money does your husband make? I don't know. Does he have stock options? I don't know. And so you really are relying on the other person to make these mandatory disclosures. It is important, and there can be significant sanctions at the court's disposal for people who don't timely make full disclosures as they're supposed to. So we have to kind of crack the whip on our clients to try and get them to get us the information, and if they don't, find ways to help them get it so they can fulfill their duties. And some people do these things quickly. Accountants are usually pretty good at doing these things quickly, but some folks, it's months and months and months of begging to get the information back from them before you're able to assemble it.
Do you